Шановні колеги, доброго ранку. Так, дякую. Ми розпочинаємо роботу другого дня нашого форуму. І як ви бачите, наша тема
of the international forum, and as you see, today's topic is the European Convention on Human Rights in the legal system and legal education in Ukraine. So we open our first panel on the European benchmarks for legal education, the transformations in Ukraine. And it's my pleasure to invite Mr. Sergei Golovate, member of the Venice Convention from Ukraine. He is the chair of the subcommittee of the Venice Committee and a former constitutional judge of Ukraine. Dear ladies and gentlemen, esteemed participants, I will have some opening remarks that will not be part of my presentation as for the timing. So I repeatedly say that I'm pretty old, and what reminded me of this, of my age, is actually this gathering, and I couldn't even imagine that it's already 30 years that I've been in this, and I have contributed to the implementation of the European Convention in Ukraine in the legal system. It was on the 7th of September in 1995 when Ukraine became the member of the Council of Europe. I was the Minister of Justice. Mr. Marchuk was the Prime Minister, Udvenko was the Foreign Minister, and I, on behalf of Ukraine, the Minister of Justice, was signing actually the document for Ukraine to join the Council of Europe. And then the next government, led by Lazarenko. So actually twice the translation, because it was from Russian language, not from the original, so a lot was changed. And then when I still was the incumbent minister, the parliament ratified the convention, taking on the obligation to respect the convention and the case law of the European Court on Human Rights, and a lot of judges actually were reluctant, stating that it was not in the law. And actually, my third term, so we said, okay, here is the law. So for judges, it was clearly stated that this is the source of law. And another small detail, when I was in the parliament, it was the Committee on Legal Policy. According to the old system, when the judges were undergoing screening, as they say, to admit to the profession, so they were going through the parliamentary committee. You know that Golovate is a difficult person, and they were always asking whether Golovate is there, because I actually asked one and the same question to all candidates. The first decision of the European Court of Human Rights regarding Ukraine. Do you remember that? They didn't know. And I asked everyone. Of course, I voted again. It was not actually to fail them. And I say, well, but it's the Convention on Human Rights. And what about soft trans after? It's not a person. There was no answer to that. So this is my first introductory remark. So I actually found only found out only on the 13th year that there is such forum, and I'm very happy to be here. And I can speak about some aspects, but I'm not going to talk about the convention itself, but about education and why. The thing is, probably you heard that the Venice Commission developed a number of documents on the rule of law. This is the report in 2011. Then in 2016, it produced the rule of law checklist in order to measure the situation with the rule of law against some measures. And then 22 years in the institutions of the Council of Europe, we are racking our heads. Why? Because when I was part of the Parliamentary Assembly from Ukraine, the translators from Moscow, Lubyanka, they translated it in their own way. And it was very tricky. But they say this is our Russian tradition. I say, okay, if it is your Russian tradition to have this translation, the Assembly adopted a resolution and asked the Venice Commission to produce an academic opinion. Today, the Venice Commission is the most authoritative body in the world. It was like the special tribunal for Russian aggression in Ukraine. So, the Venice Commission has 61 members versus the Council of Europe having 46. It has Asian countries, it has Japan, it has South Africa as members. So again, it has the highest authority, and it issued a publication as part of the rule of law activity. It is aimed at ordinary users, not for professors, not for lawyers. And this booklet first was produced in two languages, the English language and the French language as official Council of Europe languages. It is called the User Guide. But they made an exception. Another only language, it's in the Ukrainian language for your conference. I actually got it by courier post 3 days before the start of the forum. I cannot guarantee that everybody can get it. It's a very accessible, simple language. This is the gift from the Venice Commission for your forum. Nobody will have it. It's just fresh from the oven, so to say. So I have taken 10 minutes already. Well, it has eaten up parts of my presentation. Well, I will continue about the Venice Commission, and because I'm here announced as member of the Venice Commission, so I have to deliver its opinions and perspectives. So in December last year, the Venice Commission adopted another document on the topic of the rule of law, and this is the updated rule of law checklist. If you don't know what's this, I would say that in Russian it needs 8 words to translate. But in English we have 2 phrases. two notions, rule of law and checklist. So there is no one-word translation. Sometimes they use the transliteration. So this updated checklist, adopted in December last year, why it is updated to bring it closer to the recent developments that happened in the last 10 years. It contains the new chapter, Challenges to the Rule of Law. If the older, let's say, checklist, the challenges were mass surveillance and corruption, in the updated checklist, it has restoration of the rule of law. I know that it's about Hungary and Poland, and a totally new challenge, legal and civic education. I'm not going to speak about civic education because it's a different uh, topic and it's not even correctly translated into Ukrainian, but I will be speaking about the updated checklist in the system of challenges. So, what issue is raised about legal education and why it presents a challenge? In order to determine whether there is a challenge in any country, so depending on the answer, we would say whether the constitutional law is the is the integral part of the bachelor's law degree. Whether the disciplines on democracy, rule of law, and human rights are mandatory courses. Are these disciplines integrated in other legal subjects like public international law, the EU acquis, administrative law, criminal proceedings, etc., etc., etc. And the explanatory note to these issues, we have paragraph 161 that says a number of international organizations and institutions like UN, European Parliament, etc., they speak about the high quality of legal education and about the human law. It should be noted that human rights mean a dynamic conception. How it is explained for the understanding as introduced by the Universal Declaration, and the dynamic concept calls for legal education to be in lockstep with their development in time. However, the modern concept of human rights is different from earlier concepts where the rights of men and the rights and duties of men and citizens. So, what do we have? We have different concepts. We have the rights of men from the 18th century, the rights and duties of men and citizens. It's the title of Section 2 in Ukrainian Constitution and Human Rights from 1948 in the Universal Declaration that then was translated in the European Convention on Human Rights and the national systems using the European Convention must base their interpretations on the philosophy of the Universal Declaration of 1948. And the question is, what do we have here? What kind of concept are we teaching? I'm not a teacher. I read textbooks, manuals. So I decided just to review for myself, to look at it. That were produced after the constitutional reform introducing individual complaints, because this was the thrust for the analysis and understanding when the National Constitution and the National Convention have this list both.
The first conclusion that I'm going to make, and I might be mistaken, you might say that I'm crazy, but well, everybody has the right to go crazy, so I don't see anything wrong about that. So from my perspective, the methodology of teaching of human rights in particular, and potentially the entire law, there is still the link to the legal positivism. I am referring to Dworkin here, who is stating that legal positivism, that's the theory that is ruling, that states that the person has legal rights just because they have been created by some legal institutions or social practice. We take the Declaration of 1948 and we see the philosophy of natural law there. So you cannot grasp the modern concept of human rights without the knowledge of philosophic nature of the convention itself. So that's inevitably brings us to the theory that is different from positivism theory to grasp the modern concept of human rights. And the key to that is the philosophic nature that should be realized. I might be mistaken because I'm not teaching, but I think Ukrainian students might have some difficulty to master these subject matter because the first that's jus naturalis, natural law that should be grasped. Traditionally, it meant the space harmony. How can you fit it into our context? Space harmony or objective justice. A bit later, this idea uh, acquired the meaning of subjective natural law. Under some historic circumstances, that has changed. But even in Anglo-Saxon world, there were some linguistic difficulties to this, and it turned out that interpretation of this concept is very wide. Jus naturalis in the simplest form is a semantic minefield. Natural has 18 meanings. If you talk about English, use has 15 meanings. So, and that's the list, and the possible number of combinations is scary, but from the point of view of modern law studies, the leading legal traditions of theory of natural law has contributed to the concept that unfair laws are not laws. So the modern uh, experts with masters in law should know what natural law is, that natural rights derived from, and draw a line between natural rights and the rights of women, ethnic minorities, rights of children, rights of consumers, rights of smokers, etc., those who belong to specific groups. They have to be able to differentiate that. But when we read our textbooks, we run into the standard concepts of the rights of people and citizens. Do citizens have natural rights, or the rights they have are the ones that are given to the citizens by the government? So the rights of a person, of man and citizen, and that's French experience of 18th century is still there, because that's a kind of a pattern where the traditional concept of the rights of men and citizens are part of French declaration, but that's something that is cut in stone with us for centuries and is not subject to any changes. And it would be easy for you to remember that this cut in stone phrase, the rights of men and citizens, is not in line with the modern concept of human rights, but it reminds us a fly in the amber, because the fly got stuck there and it has been conserved there for centuries. So what we need to do, and that's the conclusion, we need to teach students to differentiate fundamental difference between different concepts according to Venice Commission in the latest documents, between different ideas, individual rights that exist in 18th century, law and rights of men, from the concept that is very young, because terminologically it's only 18 years old. The convention is dated 1948, even less than 80 years. And that's human rights in English, and in French it's not droit de l'homme. The Council of Europe and UN started saying droit d'homme, diretti umani. In official documents, the rights of men are not used anymore. The condition of the international law gives us a new concept that is almost 80 years old. The terms, the rights of men, human rights, droit de l'homme, though partially overlap, but these are different things. But Stalin's time interpretation into Russian of the Universal Declaration of Human Rights was translated into Ukrainian from Russian, and we never had authentic Ukrainian translation of the Universal Declaration of Human Rights. So human rights as they sounded in Russian were translated into Ukrainian, but these concepts are historically different, and there is a difference between them that should be realized and respectively applied to the things that are meant by it. That's why Western lawyers, for instance, say that human rights concept is seen in the 21st century as the modern idiom, and idiom is something that cannot be translated word for word. So human rights, that's a modern idiom equal to natural rights. In the West, the reputable scholars explain that human rights, that's prima facie trumps. So these are personal rights. So that's political trumps that an individual enjoys, and the modern concept of human rights has a flexible tool, or is a flexible tool that can be used to express the needs of fairness. Do I have 30 minutes more? Yes, I do. You do. So to visualize the interrelation and compliance of the training materials and textbooks that we have in Ukraine to the philosophic nature of the Declaration of Human Rights of 1948 that was subject to change in the course of convention application. So in 1948, that's UN declaration, and later we have a Council of Europe Convention, and so the UN declaration was transformed into the Regional Act. So what I did is I took all the textbooks that were published since 2016 until 2023, because in 2024 I finished publishing my book that is going to be out in 2 months. I analyze all textbooks that are called Theory of the State and Law, General Theory of Law, Constitutional Law of Ukraine, Constitutional Law, and Public Law. Under these titles of the textbooks that I analyzed, I identified the following themes. So that's going to be the major themes. I'm not going to be able to go into the details, but these bullet points would give you the backbone of the materials that are taught to the students. And the first theme, Marxist dogma about a human being as a social value. Third article of the Constitution cannot be avoided in the textbook. So it says that a human being is the highest social value, because that's exactly what the Constitution states. However, human mind can verify whether that's right or not. And Venice Commission helped us to do that when the opinion regarding our Constitution of 1996 was made, and it was in 1997. The Venice Commission said that constitutional draft made a mistake because Marxism is seeing the person as a social element. Marxism, socialism, communism proved that a human being is a social character. That's why it is or it has a social value, and that's a mantra of Marxism. That's 1997 that Venice Commission said that it should be remedied. The human being is to be seen as the highest value. Highest value where? In the universe, because that's a universal declaration. Wherever the person is, even in the mass, the human being has human rights that it got at birth as a human being, as an element of space. But according to Marxism, Ukrainian student is kept taught that the human being is a social value. We are professors, so we have to change something about it. I will read out a couple of points here because it might take a lot of time. In one of the textbooks, I'm not going to quote the authors and the publication. The essence of the legal status of a human being is caused by the social status of a person. That's the quotation that's the quote from the textbook. So when a Venice Commission said that it is a mistake, I can say, well, that's what the Constitution states. That's the main argument. But it is politicians who drafted the Constitution. That's political compromise. There could be some mistakes there, but science should be evidence-proved and should present the text scientifically. So in the decision of the Second Senate, there are 3 dots when reference is made to the third article of the Constitution, where it says that the human being is the highest value. In one of the decisions, the Constitutional Court states the human being is the treasure of nature, and therefore the person has the rights it acquires at birth. One of the scholars started criticizing this decision and said that they missed the word social, but I was the judge then, but the Constitutional Court conscientiously put 3 dots to avoid Marxist dogma there, and therefore it stated that the person is the treasure of nature. That's the first important point that I wanted to state. The second Soviet dogma that the government or the society gives the rights to a person. Universal Declaration repeats the provision of the French Declaration that all human beings are born free in their unity and rights, and the Ukrainian texts teach differently. That's wrong. It is the government that gives these rights. It is the society that gives these rights to a person. Soviet delegation in 1948. So the declaration was, UN declaration was approved by the General Assembly. That's a resolution. That's not an international treaty. And there were 8 countries that voted against it. Out of 8, it was the USSR and BSSR, and the leader of the Soviet declaration, and Vyshinsky was involved in that, said that we do not recognize these philosophic religious visions. Human rights are caused by the social fabric the person lives in. 90 years ago, it was Stalin and Vyshinsky who are in hell now, and the Soviet Union collapsed. But Ukrainian students still read that the human being enjoys the rights given by the society, and are equal rights of the society. The legal status of the person defines certain standards of behavior of the person that are recognized by the government as useful for all members of the large public. The state of a person in the state and the government depends on the rights and freedoms stipulated in the effective legislation of Ukraine. I will stop quoting because that's everywhere in all textbooks. The third point, the person has duties and the rights belong to the state. That's what I analyzed in 2006. What does it say? That the sovereign has rights and they are not limited, and the subordinates of the sovereign have only duties. This weird theory is accepted, and that serves as the basis for the new doctrine that is known as legal positivism. The practice of legal development proves that this Hobbes theory developed into horrible state of totalitarian state and totalitarianism in its variety. Just several quotes from the textbooks because there are many of them. Legal duties of the state, these are established and granted requirements to the conduct or behavior of an individual. Duties could be qualified by categories. The first is social ones, the duty to work. You didn't read in the Stalin's time, but you read Stalin's constitution. You haven't, but I did. It was 1936. Those who do not work, they do not eat, and you have to be imprisoned. You are truants. That's exactly the same thing.
So this is the textbook from 2020. Believe me, the duties of men in Ukraine is what is in Articles 13, 17, 19, 20 something, many articles, 41, 44, lots of articles. Where are they? But this is in the textbook. So the subject of learning, so the rights of man and citizen. So the fourth marker, it is Ukrainian abracadabra, man and citizen as a single indivisible whole. Because in all textbooks we have the rights of men and citizens, like in French declaration, the legal status of man and citizen, the system of rights and freedoms of man and citizen. It's everywhere. The classification of rights and freedoms of man and citizens, the problem of legal status of man and citizens, constitutional status of man and citizen, and finally, a quotation. The principle of guaranteeing the rights and freedoms of men and citizens are enshrined in articles this, and this, ending 102, obligate the state to ensure that man and citizen have real opportunity to use the granted by the Constitution rights and freedoms. Well, then, about duties. Yes, I have covered that. And the same about the rights. The same formula is the main duties of men and citizens, legal duties of men and citizens. So the spectrum of duties of men and citizens, and in all the sections. So we know it's the title of section 2, the rights and freedoms of man and citizen. But again, we are to understand that it was a historical document with the in the middle of historical development. So we really were taught human rights at all, or the theory of natural rights and natural law, anything about natural rights at all? No. On the contrary, we could find that distorted by the Russian regime the translation of the French Declaration, because it starts with the phrase, from their birth, men are equal in their dignity and rights and remain, and the last part was removed because it merited explanation, because in the society it's the same as in the natural state. So this is another marker. So it's not compatible with the modern philosophical concept of human rights. I asked myself, what is the source of this Ukrainian abracadabra, as I call it, man and citizen? So it's one. It's like Siamese twins. We cannot divide them. Can this one agent has the same rights and duties? So I started to look for the answer. My hypothesis is that it's the Stalin Constitution from 19 36, it has section 10 titled Main Rights and Duties of Citizen. It is a little bit of adjusted, but this is the Stalin's constitution, and still we haven't yet divorced from it in our academia. Well then, going further, yes, we are to separate these notions and explain to the students what are the difference. So the status of man according to natural rights and then the rights of citizens, as smokers and non-smokers. Having taken the Soviet formula from the constitution, it got a little bit sugar-coated, a little bit veiled when Brezhnev was adopted the constitution. Maybe I'm the oldest of you, but maybe somebody remembers. Of course, it was not Brezhnev who wrote it per se, but it was a seemingly public discussion, and there was an anecdote. Well, all the time you can hear this Konstituция. Konstituция, what's that? This is like a powder. A powder. Yeah, I'm not going to finish that, but the fifth marker, the communist mantra about the unity and intertwining of rights and duties. Yes, you read that. According to this formula, the rights and duties of citizen, again, it's the Stalin formula. And it led to this interrelation. I give you a couple of quotations. In a democratic society, interrelation and unity of rights and freedoms is manifested, and it is duty is the method of ensuring rights. There shouldn't be rights without duties. There mustn't be duties without rights. Another, in order to enshrine the rights or affirm the rights, I, as a citizen, want to affirm my rights in a democratic society. I take on a duty and perform the duty. Well, then, yeah, I'm at a loss. Now, I'm not going to go deeper into this. However, we have another textbook, The Principle of Unity of the Rights and Duties. There shouldn't be rights without duties and duties without rights. You know, it travels from one textbook to another without reference, but it's a kind of a repeated motive. I have found this source for this mantra too. In the Soviet time, so there was the book, author Malitsky, he published Soviet Constitution. So you're lucky that you don't know him. So it was about the early Soviet Constitution of 1924. It was approved as the textbook for universities. The duty of state is complemented with rights, and the rights have corresponding citizens' duties, etc., etc., is a kind of a chain of rights and duties. If you give me 10 minutes more, probably it's the funniest or the saddest. I have found the source of this thesis about the intertwining and interdependence of rights and duties of citizens. 99% of you, of those present, you don't know what communist regime is. Yeah, we have somebody, and you may remember that there was the Communist Party of the Soviet Union, and we had Communist International, the world's unity of all communist parties, and they had a beautiful song sung by all communists, and at certain time it was an official hymn of the Soviet Union anthem. Well, in Soviet times, this song was sung at all festive gatherings because it was obligatory for the society that was building a communism. And the text by the French poet Jean Potier, member of the French Commune, and Pierre de Gaiter composed the music. And it was translated in all languages, including Ukrainian. And it was the best Ukrainian translation by Mykola Voronov. And I would read out 3 texts: French, English, and Ukrainian. French, please. And now, Ukrainian, you remember very well the beginning. So the Ukrainian translation. Again, no rights without duties and no duties without rights. So we are where we are now. So it's number 6. So actually it's affection to Moscovia, and it's Muscovite rubbish. What I am about is that again, so the Russian translation of fundamental rights. Some examples. Enshrined in the Constitution, the rights and freedoms are called main. Again, about main rights of men, the system of main rights, main in brackets constitutional, rights and freedoms, well, to cut the story short, so I don't know. I don't understand why are we talking about this main rights. And this all comes from Moscow. The very, very recent textbook in the 2020s, the reference to a publication in Moscow from 1959, and that was the translation from German. It was about the state and law in Germany as a textbook. And so, in order to explain the main rights, this is the reference. We refer to the dictionary of the Ukrainian language. What does mean основной? And it has the antonym. So in the Ukrainian language, it's the most important, because there are less important, primary, there could be secondary, there could be leading, it could be the largest, predominant. I don't think that it corresponds with the notion of fundamental rights. So the perception of rights as main actually leads to this division into kind of a main, then kind of a other or secondary. So the primary and derived, main and other, main and optional. So this is all that we can find in the textbooks. It's understandable that this is kind of a masterpiece. It assumed even a new form because I have found with one author that the notional, constitutional, main rights, these are synonymous. Well, come on, people. It's hard to understand. The classification of rights and freedoms. Do we find anywhere? There is no classification because the nature of the rights in different documents is have different. So we have social, economic, cultural, etc., and they are of the rights of different nature, as you all know very well. And I'm drawing to the close. It's so we continue listening to you. That was the last marker, number 7. So we also find in textbooks the proposition to distinguish rights of men and freedoms of men. Only one quotation. The rights of men, from the point of view of legal constructions, should be distinguished from freedoms because the rights is something that is ensured by the duties. Because you have a duty, you ensure my right. And the freedom essentially is the right that has certain specificity, and the freedoms is the freedom of conscience, the freedom of speech is established by legislation. It means that by nature I do not have the freedom of speech, the freedom of conscience, because it is only established by legislation. And the last 2 weeks ago, there was a forum in Kiev at the Supreme Court. And yesterday you mentioned that it was about the convention.
It was attended by the president of the European Court. And when I was reading on the news about that, the judge of the Constitutional Court said about the convention, European court case law application require not just the reference to it, but a deep understanding of the context. And he gives an example. The Constitutional Court of Ukraine, in its jurisprudence, uses the principle of friendly attitude to international law. I have international law diploma. I might have missed that. I have a PhD in international law, and I never read about anything called international attitude to international law. But there is the entire textbook that has been issued on that. That's for masters. Where this principle of friendly law to international law are described, and allegedly it is widely used in Europe. A rule of law checklist of 2011 and in 2016 quotes one principle only, pacta sunt servanda. That's about the relations between international and national law that binds us to abide by international treaties and enforce the judgments of other courts if we find and recognize their jurisdiction. There are two decisions of the Constitutional Court before I joined it. I joined it as international lawyer professional, and I explained this to them that this principle is not there at all. We or somebody thought that that's something that German courts use. We talked to German lawyers about that. Germans, because their Grundgesetz is recognized as the primary of international law and the European Convention. So the federal court was supposed to find the way out of this deadlock. How can you recognize gazettes above the Constitution? And the way out was if they interpret Grundgesetz, they interpret it in relation to international law. So they talk about interpretation that would be friendly to international law. That's just German experience, and that's only about the interpretation of the Grundgesetz. They just for Germany. It didn't go beyond. I have translation into English, and that says in English, interpretation of Grundgesetz is open to international law. So open is not hostile, and that's basically it. Thank you. Thank you very much. You set a special tone to discuss legal education. We saw smiles, and we felt some indignation as to the things that we have in our literature. We can proceed as a moderator. I can give the floor to Dmitro Hudemas. Thanks a lot, Mr. Holovate. A lot of things re-echo with what you said. Let me quote one provision. Specificity is the way of existing moral that shows to the outside. So identity of the will, the duty and right merge, and the person has rights because it has duties. In abstract terms, I have the right, and somebody has a duty regarding this right. So my well-being, my rights should be linked to the duties. A slave cannot have duties. It's only a free person has these duties. Only identity is the basis that we should stick to, and it's not Soviet quote. That's hell. That's philosophy of law. That's about the link of rights and duties. It's not a Soviet concept. It seems to me that we have to give it a thought how it was reflected in Ukrainian theory and practice. We have some legacy, historic legacy of Soviet times, and it doesn't mean that everything that we had there was of communist coloring. We do understand how didactic materialism was developed, but some of the concepts, if you talk about a categorical imperative of Kant, then it's based on the duties. So that's just some of the comments and reflections on what I heard. Well, hell and that's something that reflected the concept. Venice Commission said that modern concept of human rights should be taken as a flexible concept. Neither Kant nor Hegel were aware of that. So that was a historic moment of the development of humanity. We are talking about human rights concept in its modern nature and the differences. And I didn't cover the differences. You'll have this in your hand in 2 months, and the challenges are covered there. And how you can address these challenges. Everything is covered in here. So you may disagree with that, but it uses Western sources. Hobbes was quoting that too, but modern concept states that the duty is vested with the government. That's the last sentence of Article 3. And the main duty of the government is securing human rights and human rights is the philosophy of the doctrine of substantive law that is reflected in regional and international levels. Thank you. We'll have more opportunities to continue this discussion. With your permission, let's focus on the practical issues of the development of legal education in Ukraine. And today we managed to have experts in this room, and I am honored to moderate this session because legal education is close to my heart, and I am happy to introduce speakers of this session. So that's going to be divided into two sessions. We have representatives of different law schools of Ukraine from different geographic parts of Ukraine, which is a great thing to have. We have representatives of employers, international experts, representatives of lawmakers, and with your permission, let me structure the first session on legal education in the following manner. I would ask the participants to spend 3 minutes to outline the state and the forward-looking steps of legal education, and then we'll have moderated discussion on some specific issues of the reform of legal education in Ukraine. And I'm pleased to start moderating this session with giving the floor to the Dean of the Law Faculty, Ivan Franko National University, Mr. Burdin. Good morning, dear colleagues. Welcome to the second day of this forum. Let's try and stick to time frame. So I have 3 minutes, and let me use the time to express my perspective on the legal education reform, so-called legal education reform. I am using this wording conscientiously because I am going to deliver some controversial bullet points on it, because as of today, the reform or the issue of legal education reform is a very good educational trend, and it is used by many. There are many roundtables and conferences, but honestly speaking, when somebody says that legal education reform is going to be on agenda, I start being nervous immediately, because my immediate thought is, okay, what else are we going to have? What kind of other turbulence is going to be introduced? Because as of today, legal education reform is full of uncertainty, because that's the reform without the beginning and end. But let's start with what I think about it. Around 15 or 14 years ago, there was one international organization, I'm not going to give the name, that said that there is a project that you can work on that's on legal education reform. And legal education reform was launched at Lviv University. We had to substantiate the beginning of this reform. Why legal education? Does that mean that any other education areas do not require reform? And it was claimed because legal education is in need of reform because allegedly it's the most corrupt and in phases to some legal acts, there were not quite right sentences that entrance exams or secondary grade school graduation exams should be reformed because they are corrupt. I don't know why, but well, that's what appeared, and teachers agreed with that. So we launched the reform that is ongoing for 15 years. So what's the outcome and what has been reformed? And I couldn't fully realize what was to be reformed and what was the purpose of the reform. So we have to show what was wrong about it and what is to be remedied. So we changed the concept of the entrance exam to get masters. We got new exams introduced. We have the single qualification exam introduced, and as a dean with 10-year experience, these were really positive steps. There is nothing wrong about that. We saw the standards of legal education developed at all levels. That's for bachelors, for masters, for the third research scientific level. But the standards and competences, the way they are worded and defined, is very general, and any curricula could be adapted to these standards and get accreditation. But in my understanding, were the entrance exams that was subject to intense reform, and that was the core of the reform, and graduation exams, that's this single exam that was the result of the reform. These are really technical elements of the way the education process is organized. If you talk about the reform of education, education is not about entrance or graduation. Education is the process that we have to acquire this 240 credits for the bachelor's and a different number for the master's. And this process could be a subject to reforming. And what I'm thinking about is whether the reform that we are talking about aimed at reforming the education process, that's a 4-year or 1 year and a half process. Unfortunately not. And to stick to the time allocated for me, let me say the following. I recall my schooling. That was 1993, 1998, and I believe that that was the time, it was Soviet times, but in legal education, that was probably the most stable and predictable period. And let me explain why. Having graduated from the law department, the graduates were ready to work in any area of law. They could be defense lawyers, they could be investigators in different bodies, they could be prosecutors, and that was the advantage of the classical traditional type of legal education that we had then. as of today, it is absolutely disbalanced. So, if you talk about the necessity of the legal education reform, then I would rather focus not on anti-corruption of entrance and graduation exams, but the main focus should be on the content of education process that would enable classical education institutions train classical lawyers that would be ready in any area of law. Thank you. Indeed, when we talk about the reform of legal education, everything is important. The design of the curricula, the process, and the balance between autonomy of educational institution, because we couldn't be the same, and the governance on the part of state. So, to continue what you've started talking about. We are looking forward to Mykola Stefanchuk, member of the Parliament of Ukraine, and his position. Over to you, please. Good morning, dear colleagues. I'm very happy to be present at this forum. Legal education reform. In our committee, we have another working group created with a focus on a legal education reform. That's either seventh or eighth working group that we have established. What is it that we are going to talk about there? The thing is that legal education reform is not a revolution. You cannot tear out one page and replace it with other. That's about evolution and evolution only. Unfortunately, the level of education and legal knowledge that students acquire is not fully in line with the requirements of today. Earlier, it was possible to use one textbook or have a set of lectures and um, represent interest in court, but today's challenges are different. That's languages, law of the EU, that's AI, new anti-corruption legislation, that's new vision of the jurisprudence and case law, and all of this should be mastered very fast. So the idea of legal education reform is comprehensive, starting with the law. That's the law on the highest legal education and primary access to profession that serves as the basis for it. But on the basis of this law, we'll see orders, instructions developed. Why? Because educational process should be not really overhauled, but rather have oversight. The best things should stay, but things should be improved. Will have to be improved. We are not talking about erasing one thing and replacing it with other. That's monitoring that we are going to introduce, and that's the very idea of the legal education reform. Briefly speaking, here is the key elements of legal education reform plans: the modernization of the education to bring it in line with the best European practices. We've analyzed the European practices and drew the conclusion that the curricula that we have at law departments should be cross-cutting. So this should be cross-cutting training of masters without bachelors in between. Why? Because an educational institution develops comprehensive curricula as to what kind of lawyer they're going to train, then unfortunately we have deplorable examples because educational institutions that have nothing to do with the law departments and law schools in some way, just to formally being in compliance with the requirements, train bachelors of law, and then these bachelors enter Shevchenko University, Franco University, Kharkiv, and Odessa University, get master's degree, then enter a job market and claim that they entered the best law schools, but they have only masters from these schools without bachelor's degree, and that's where the problem lies. So by doing this type of reform, we'll improve the quality of education and will make educational institutions responsible for the quality of knowledge that the graduate has.
So another complicated story. We are negotiating to see that only civil law schools would be able to educate lawyers. We have education institutions under the law enforcement authorities. And what is the logic here? A lawyer's job is to defend human rights. They should not feel tied by hierarchy. They should be free in their thinking and protect human rights. These specific education institutions have different mode because they focus on the ability to react to fulfill orders, and they educate people for the law enforcement. And the psychology is different in this area, in the security sector. So these are people having a set of instructions, and they need to be able to follow the instructions very quickly. And educating lawyers only in the, say, civilian institutions, it would impact, and that is why we are currently conducting discussions with these institutions. And it would be logical because the law enforcement activities, access to weapons, this is specialized knowledge, specialized methodology of training. And civilian institutions, they really should focus on training lawyers. The second thing is access to education through the system of primary professional selection. We can consider these high scores established for lawyers in the first year of studies. Sometimes we hear dissatisfaction. Let's enroll everybody and have some interim tests. And let's be honest, how many students drop out because of failure, academic failure? It's very rare. Volodymyr recalled his time at the university. I remember my 75 success rate. So it means that 25% dropped out because of failure to succeed academically. And until we reach this graduation rate, we need this primary filter to select students with highest ability to learn. As for the quality of education, of course, we need to review it. This is engagement of external experts and its academic mobility. its language proficiency when it comes to the EU languages, monitoring, accreditation, but this is more at the level of secondary legislation that could fine-tune the entire idea of education reform. Well, this is the main vision about the legal education reform. And to conclude, maybe a sort of an illusion or a dream, it's after this is finalized, is actually to create a single access to profession. The thing is that today, judges, prosecutors, lawyers, they have very different training. There is a school of judges, there is a training center for prosecutors, we have the National Bar Association for lawyers, defense lawyers, and they take exams with very different conditions, very different scope of knowledge and skills, and then they meet in the same courtroom. They take decisions on the same case with regard to the same persons. And the judge, the lawyer, and the prosecutor, I believe, should have the same basic minimum of knowledge and competences. For the judge to know and to be able to ensure that defense, that the prosecutors do not abuse their office, so that the defense lawyer knows how to defend the client, and the prosecutor knows that for any, in case of any violations of breach, the accused could escape liability. So these are the key things that I wanted to highlight in the vision of the reform of legal education. Today, the draft law has been finalized. It is being now reviewed in the expert department and the legal department of Parliament. And as soon as we receive the review, we would again consult you in order to understand to what extent this law would be helpful and efficient to ensure quality of legal education. Thank you. You have actually raised all the issues that we're supposed to discuss today, and I think it is great that we have representatives of different law schools and they could share their visions and perspectives. I share your views, and I agree that the development of legal education should be an evolution. And even after the adoption of this law, because we do need this certainty, I think that every law school would go through certain transition in order to implement the new requirements. That probably the first concept of legal education reform, it was issued maybe more than 10 years ago, and then we had another. So I think that the adoption of a new law should become a common solution. We are happy to have you with us And we are glad to hear that we are to expect the kind of certainty. Now it's my pleasure to turn it over to Tatiana Kolomois. She is the Dean of Law in Zaporizhzhia National University, working in very challenging conditions. Tatiana, welcome. Thank you for the invitation, and I do agree with what has already been said. And in our law school, this is very difficult time since 2022, and we feel the need not only to survive, but also to concentrate the efforts to reform it, to look at the challenges, and to continue what Mykola has been saying. What is crucial? Who are we training? Who is training, and the content of training? The problem is with the access of legal education is crucial because the input actually will determine the output, and we have huge demand. There is headhunting for even undergraduate students, and this is the testimony to the fact that the students should be very motivated because the initial education will be determinant. And I think that the demands and the requirements set they have worked. And this CAT score allowed us to really have motivated students. And we see them in any case. The CAT score actually must be present in the admissions. Then when we look at the faculty, so we here have people representing the sectoral councils. We can look at the accreditation procedures, especially criteria number 6, and we can see that there are law schools that they just produce the workforce that simply ultimately cannot compete with alumni of Lviv or Kiev Mohyla, and it's very problematic. They are not in the equal conditions, and that is why the review of these schools it's a very important issue. When we look at the law and law enforcement, it's time to actually distinguish. We have these standards for law enforcement activity. They say that they have very special material infrastructure to ensure adequate training of these specialists, these professions. The civilian institutions cannot actually do that. And it's high on the agenda. And if we look at the accreditation results, and when we see just expert group specific conditions, and we have A or B, and in civilian they have at least one E, saying that the physical infrastructure cannot ensure the quality. So we need to concentrate on the quality of legal education and not to use law enforcement activity as the kind of a backseat. So during the first years of war, we have seen a huge outflux of people, of students, their parents, either to other parts of Ukraine or abroad. And so we looked at what we need to do with our programs. What is important is to say that in order to ensure good training, we need to focus on content. We allocate a lot of hours in the humanities, and unfortunately, we are losing during the first and the second years here when it comes to the fundamental training. So later, the cases of dropout is rare. They are looking for employment already and they have certain perspective. And we all remember our experience, criminal, civilian disciplines. This is the bedrock. If we look at the official data and the curricula, we see these basic disciplines. They are represented in smaller percentages. There should be autonomy, etc. But we need to have very serious attitude to the content. And as for the faculty and workforce, these are not simply teachers and not simply meeting licensing conditions. There should be also linked with the practice and practitioners. So the teachers should also have practical training depending on the courses that they teach. Then the lectures would be interesting, practice oriented, and they would be in high demand. We initiated at the level of the project. There were 41 schools participating. We thought about in-service training program for schools that are part of this initiative in Ukraine. So we have a lot of offer when it comes to in-service training. Why can't law schools unite in order to establish several centers and to offer professional in-service training to see that actually the state can offer them good quality in-house product, and it can't be only a distance learning course. It will help preserve what is best in every school and to see the specializations and to have these internal linkages.
If you plan to single out lawyers, then you will have stronger education for lawyers in Ukraine. And speaking about financial resources, that's a very important issue as of today, given security risks. I will speak about us. We had 8 hits at the facilities, and it's very difficult to preserve uniqueness. Partners help us a lot. We appreciate industrial partners and international partners, but the risks remain. So maybe thanks to having national fund and thanks to its mobility, we could unite law schools, and it would be very helpful for all of us. Thank you. Thank you, Tatiana, for your perspective and experience. What reacts with me is one of the statements you made at the beginning. That's about the number of law schools. 160 plus universities train lawyers at the moment. So the delineation of training between lawyers by educational institution with specific conditions of training and civil institutions is very important now, given the different conditions for entering and graduating and the uniform qualification exam. We don't have regional quota in Lviv, but we see that the number of the students that are supported by the state has decreased. If somebody is dreaming about the education, then I need to get 150 points. I need to study. I need to sit in for a uniform qualification exam and then take entrance exams to become a defense lawyer, for instance. That's a long path, and for a lawyer, it shouldn't be easy because we are talking about qualification. On the other hand, we are in the transitional period of time when we have to develop the model to provide for certainty. Let me give the floor to Yuri Ponomarenko, Vice Rector of Kharkiv Law University, named after Yaroslav Mudry. Thank you for this discussion and possibility to participate in it. So, the beginning, we need to talk about the general vision of the legal education reform, and then we'll talk about specific points, whether that's bachelor's and master's, or just master's, whether that's civil educational institutions or the institutions with specific conditions. As to general approach to legal education reform, then let me just warn you against some things and to say that when it comes to administration of legal education, I'm in it since 2009. And since 2009, I keep reading and hearing about the necessity of legal education reform. That's 17 years. 17 years allocated for the legal education reform, that's probably too much. What are the outcomes there? There are some results. So we have the reform of entrance exams, graduation exams, reform of bachelor's and master's, but we cannot say that reform has been completed and we have the results that we've been dreaming about. Why? The answer is because we haven't agreed what kind of an ideal result we are aspiring for in the legal education. And until and unless we agree about this, we'll have another 17 years to reform legal education. Therefore, this discussion is needed for us, representatives of all our different law schools, jointly with the representatives of the government, Ministry of Education and Science, to sit down at the round table and agree. That's the result we want to have. Key things, conclusions, and then as soon as we've agreed on that, we'll get down to business. Unless we have this understanding, we'll keep reforming legal education for a while. And as to specific issues, I'll take the floor then. Thank you, Yuri, and fully support what you've said. Let me give the floor to Lyudmila Deshko, representing Kiev Shevchenko University. She's also the member of the Council for the Quality of Education. Thanks a lot for the invitation and possibility to participate in the discussion. From my perspective, legal education reform and quality of education has always been relevant. We see the public relations changing. We happen to be in the situation when European integration and war have an impact on legal education. We believe that there will be an element of post-war recovery, and law schools keep asking what kind of legal education we need to have and how to provide for its quality. When we develop a specific a syllabus, or whether that's bachelor's, master's, or the primary education, we always ask the question, what are the competences we need to teach a law student that is enrolled today and is going to graduate in 4 years, how public relations are going to be different then, and whether this graduate is going to meet the challenges of job market. Because when we started training law students, so we need to be sure that this graduate will be able to find a job in the job market. So whether legal community or law schools or partners should consider all of this. And Yuri said that he started working on this in 2009. I started doing that back in 2008. I started with the OSC and the reform of the curricula on the theory of law that we reformed. That's the basis for the legal education. Then we had a large conference in Lviv. It was in 2011, where Mr. Halovati was present as well, where we discussed the content of the program, rather curricula on constitutional law. So that's the process of developing and improving quality of legal education is ongoing, and a lot has been done thanks to law schools and representatives of law schools with the support of the partners. We have dramatic changes in law education, that's legal clinics and their role in training lawyers, where they acquire necessary competences. Today we spoke about the different trends. That's practical knowledge. We know that the first bachelor's degree has 15 credits for the practical experience that should be acquired. At least 5 credits should be got by the student. If you correlate that with the other credits, that's quite a lot. And out of 15 credits, it is 5 that should be a practical experience at public prosecution and courts. And here we rely on partnership relations because lawyer is trained through acquiring fundamental knowledge, and then this practical experience gives the student practical skills. And then the question is how formal this approach is. And here we rely on our partners where they acquire this practical experience. We call them stakeholders. So students acquire this practical experience at our stakeholders. So what we need to do is make sure that a lawyer that starts working in court would acquire not the skill to register the motions, but real practical skills that should be acquired with the assistance of our stakeholders. When you talk about masters, we have 20 other credits that are allocated for scientific research and practical experience. So here we are trying to combine theoretical knowledge with practical ones. Another trend when we talk about the quality of higher legal education is the fact that the concept of the quality of education has changed. Now, what we are talking about is we rely on a higher educational institution to this end, namely to the system that it has that allows to train competitive professional, and respective commission and ministry can assess whether higher educational institution is capable of training professionals to this level. Then the question is, what are the criteria that would allow to assess this higher education institution and the curriculum that it has, whether it trains high quality professionals or has some deficiencies. These criteria have been developed. There are 10 of them. They have sub-criteria. They have been approved by the resolution, and our council is guided by these criteria to analyze each curricula of higher educational institution to be able to assess whether it meets these requirements. In some educational institutions, we are seen as partners that can assess curricula and provide recommendations to improve this curricula. But unfortunately, we also have instances when we, while assessing the education institution, provide recommendations, but a year later, we see that nothing changed, and we start the process again. So we amended Ukrainian legislation to make sure that quality of legal education and higher legal education remains high. And starting September 2026, we are going to have the procedure of post-accredited monitoring introduced. So if a legal institution passed accreditation, they are going to be subject to post-accreditation monitoring. That's a third year of curricular implementation, because certificate is issued for 5 years. So in the third year of its accreditation, we conduct assessment as to the way recommendations we provided are implemented. If educational institution does not implement recommendations we provided, the educational institution is going to face the consequences that could range up to a withdrawal of accreditation certificate. So that's an attempt to make the quality of education high, and they have systemic nature. We are talking about practical experience and formal education, started by correspondence. That's another issue. So all these issues as to the quality are going to remain relevant all the time, because as soon as we stopped and claim that education has been reformed, and until and unless we keep improving the quality of legal education, so we'll lose, because that's the process that is ongoing. Thank you. Thank you, Ludmila. You mentioned accreditation, and in this room we have 4 people that are engaged in accreditation. Let me just briefly say that accreditation, that's the word that causes fear and horror of law school representatives, but we would like to see this process as the possibility to hear out the opinion of uninvolved party, and that's the possibility for you to get improved. Legal education is in the focus of the European Commission, as you know, and the report on Ukraine states that specific recommendations and assessment of legal education. And let me just add that the issue of legal education is part of the section of the rule of law as a challenge and accomplishments, because there is a positive comment of the European Commission regarding the reform of legal education. So let me give the floor to Oksana Tsembrivska that represents Pravo Justice. Thank you. It's great that legal education is on the agenda of this type of fora more and more often. That's what we see in the course of last 6 months, and that's very valuable. Pravo Justice and the EU in general is providing systemic assistance to strengthen rule of law in Ukraine. We support different reforms. That's a judiciary reform. I'm not going to mention how long it has been going on, and when it was launched, we contributing to the development of legal professions, public prosecution, and we see the results. But along with that, we see continuous process of reform, and that's going to stay so until and unless we get emerged in the legal education reform, because a judge, a defense lawyer, and prosecutor are the graduates of a specific institution where they got trained. So it was nice to hear that it is time to systemically review legal education. The issue of legal education is a subject of EU accession process, that's subject to negotiations. That's Section 23, 24, justice and fundamental rights that make cluster 1 in the negotiation process. And that means that Ukraine can be successful at negotiations only when these requirements are met, and legal education is part of these requirements. Another important thing is interim benchmarks. That's Section 23 of the negotiating process. And in March this year, Ukraine received these requirements, and the issue of legal education is part of it. Quality of legal education and access to legal education.
So we need to understand that this is a very important strategic aspect that influences the entire system of justice that Ukraine is building. And without it, unfortunately, as a state, we won't be able to successfully complete European integration. The second thing that I wanted to note today, I was happy to hear about the access and quality of education. These are the key things that are cross-cutting in all the European Commission documents. Ukraine has a plan how to move forward. So the vision is here, and it is commendable that the Cabinet of Ministers last year, on the 14th of May, adopted a roadmap on the rule of law with very clear vision what needs to be done in legal education. And the key issue, and every speaker has noted it, is to separate the education and the training in different kinds of institutions. And this is the key aspect that the European Commission stresses, and it is linked with the quality of graduates. Marta spoke about the number of law schools, and it is also linked to the question of quality. We have more than 160 law schools in the largest EU member states. It's not more than 10. This is also about quality. we are to understand what kind of lawyers we are educating and training and what would be the ultimate output and who will be later in the courtrooms, etc. So I think that the first step that we are to accelerate, and Mykola, we all look forward to the registration of the draft law in order to have a good dialect and how to move on with the adoption of this law. Because according to the roadmap, it should have been completed in March, but it's good that we are at the home stretch, as you have said. But again, I would repeat, it will be only the first step. Unfortunately, or fortunately, without proper implementation, the law would remain only on paper. And all the harmonization efforts, it's only the foundation. And then we will move on with implementation, and we would have to show the track record of adaptation and what is the ultimate result. There is a lot of work ahead, and it's good to hear that speakers from different parts of Ukraine have raised this issue, and this tells us about the relevance. And hopefully, we will continue this discussion in Parliament soon. Thank you. Indeed, the European context, and together it is raised at the international forum because we look at it not only from the purely domestic perspective, we look at it through the lens of EU integration, and we think about also preserving our traditions and legacy. It's not just blindly copying best practices and fulfilling recommendations, but also thinking that we do have a lot of positive things in Ukraine, and it's my pleasure to give the floor to Mr. Wenger from Kiev Mohyla Academy. Marto, thank you. Thank you, dear colleagues. First of all, for the invitation and for the wonderful event and this panel, which is extremely useful. If you would allow me, I would go back to the general topic of the forum, and I would like to thank Mr. Galavate for the keynote speech. Because reform, it's not about the form or the draft law. The main problem with the reform is the mindset and the way of thinking. So we use the word law school to name any institution that has a law faculty or department. And it means that we do not have also the common mindset in the light of the convention. Sergei has raised some issues of terminology, but we have never had a discipline of theory of state and law. And we thank our CE and projects and people who made it possible. It's Natalia Stupnitska and many other people. So we published a textbook on the general theory of state and law. And a lot of so-called law schools said, how dare you? In December, just a group and the Renaissance Foundation invited me to give a lecture, very short, 10 minutes, and I also told about kind of and that this theory of state and law, it's the same as to teach, instead of constitutional law, the state law. Or, these are obvious things, as it was kind of the primate of the Communist Party, and several judges, including the judges of the Supreme Court and Anti-Corruption Court, the ones that are the beacons and the hope of modern Ukrainian jurisprudence. And they say, can we have a coffee and tell me what's wrong with this question of state in the sphere of law? So when we speak about legal education and light of the European trends, it's about mentality, mindset, and unfortunately, it is not in all parts. And I think that also the draft law merits improvement. So, how to remedy this? Well, it's not the formal things that could help, and I think that the key instrument is the development of Ukrainian jurisprudence. It's the same as we compare, let's say, some indicators in anti-corruption efforts. It's the same as, uh, fighting Soviet positivism. So, people didn't like asset declarations, but it performs some functions in the society. We can take some quantitative indicators. For example, how many law schools have taken part in institutional, uh, like part of the programs like Horizon, etc. And this is the indicator of European integration and our way towards the right mindset, because the consortiums and serious universities are reluctant to work institutionally with us because they believe that so far we have a different mentality, but we have some light and we have some accomplishments even here. If we link mentality and the development of science, it does require resources, and this socialism is still there. Somehow the ministry and the government, they think that you can do your research somewhere in the break between the lectures. Even the salaries, let's be honest, wonderful initiative to raise salaries. I don't know where, but in the majority of national universities, it's paid through the special fund, and it sounds odd. Speaking about the content and support of the state, again, I want to refer to Sergei. He remembered the psychiatric care, but I want also to refer to it. It's one of the decisions of the Constitutional Court when the court was right to interpret the case law of the European Court through the lens of the article of the Convention, comparing with the article from the Constitution. And this is the example of the mindset and mentality. This is lacking in the practice of courts, including the Supreme Court. And I think that we need to speak about it. And the last thing, how to motivate. Tatiana, thank you for your work, for your heroic efforts and solidarity. So you were right to say that we ought to care about substance in the in-service training. So we are lacking in sharing and generation of ideas, and sometimes the competition between law schools leads to the fact that we sometimes even look ridiculous. You know, we have a lot of events on behalf of Kiev Mahila in Oxford, in Jagiellon University, in Germany. We want to present some joint efforts and accomplishments, and it would impact the quality of education and academic integrity. Unfortunately, today, we do not have the necessary filter. In Kiev Mahila Academy, we do not have problems with admissions to the master's program, but it's a disaster because we receive students who are not, so they have, you know, excellent marks, but they show some ignorance in the most basic fields. So I am sure that even without adoption of the law, we need some filter that would use some market tools, as it is in all civilized countries, who can graduate and who cannot graduate. And I think that the tool that you have in mind may serve as a filter. And the Ministry of Education has a conflict of interest because they set the standards and they administer a lot of exams, and they also evaluation. And the tests should be administered either by the professional community or by the Ministry of Justice. So I believe that these ideas would really be accepted by the community and would help us on our way to the application of the convention. Yes, indeed, you have raised a lot of key issues, and the concept of the legal education reform, it establishes the master's program with the testing as step to ensure the quality. We have 15 minutes before the break, but we would continue from a different perspective, and I allow this time for comments. I see your hands, Irina Kushnir, the Council of Europe. So, bravo. It has been really a deep and structured discussion. I want to thank for mentioning the decision of the Constitutional Court, because I was the author of the motion. There was about 10 other motions of the similar nature, and what we noticed when there was the motion linking the national law, constitution, and convention, a lot of departments were against this approach. So, what is, do I remember it correctly? A lot of teachers were against it. You spoke a lot about the legislation and about the role of the state. My question is, what should be in legislation to ensure the quality of teachers? Because this is a precondition for good quality students, because we test them, we send them to do the practice, but what do we do with the teachers? Where do we take where do we get good quality teachers? Well, it's difficult to give an offhand answer, but this is not the teacher who focuses on meeting formal requirements. This is somebody who has time for reading, for reflection, for self-learning, deeply understanding not only the discipline, but has a philosophical mindset with broad and critical thinking, who is not locked within the domestic system, but knows the systems of other countries and knows the international law, even though they specialize on criminal proceedings or environmental law or something. And finally, this is somebody who is able to say no to the boss. I see, for example, that my academic freedom allows me to teach it in a way that I see fit within the scope offered by the curriculum and with the decent pay for the work. It's not somebody who is thinking how to earn additional money because they cannot uh, afford decent living with the salary they receive. So now I give the floor to one of our stakeholders, the head of the Economic Court in Lugansk Oblast. Thank you. Yes, indeed, I've been listening carefully to this panel, and I understand that there are a lot of problems, not only in the judiciary, but, you know, so we ultimately face the situation as it is. And I also teach at the National School of Judges, teaching adults, and it's my passion. I teach at the university named after Dal. It has survived 3 relocations with huge internal problems. But in Kharkiv, I also cooperate with a number of universities. And I would, so you ask about the teachers.
You're teaching theory in most of the cases. So the faculty teaches theory, how it governs different things. Legal norms, that's about theory. But when it comes to the process itself, as a judge, I can say the following. When you develop a procedural document, at the beginning, you don't have any skills. I'm talking about the students. If, for instance, the claim, I can know the theory, but that's knowledge. But apart from that, you need to acquire skills to do that. And lawyers, that's about practice, not so much about theory. So theory wouldn't replace practical skills. So I try to organize classes with the use of animation on different legal issues, and I see how it helps students to draw a line between decision and sentence, for instance. And when a student drafts a claim and should substantiate it, that's a great skill that they can acquire. At the same time, defense lawyers and judges have their own professional specificities, and given the standard education and, let's say, developing specific skills at the educational institution, that wouldn't be enough. You need to acquire that when specializing. So those lecturers that are just researchers without any practical experience, they wouldn't be aware of all these practical nuances, and we have lots of them. We have the Uniform Register of Court Decisions, for instance. There is a lot in there, but you have to be in the know to be able to deliver that. So if it were lecturers whom we invited to attend the trial, and it wasn't simulation, it wasn't moot court, it was just a real hearing, and I know a lot of lecturers did that. So in other words, when we had a cooperation or interaction of a practitioner and a lecturer, that was mutually beneficial process, because practitioners learned from lecturers learned from practitioners, and lecturers saw the way it happened in reality, because they are not part of all these trials. Every time you have a new hearing, there are some new things that crop up. I liked what Tatiana was saying. She was talking about the practical experience that students acquire in the course of training. So it depends on the stakeholder, it depends on your supervisor. If you're lucky, that works. But if not, then the results would be nullified. But if you have specific centers set up, let's say at courts or at some other institutions where law students could um, take their practice and would have very good mentors and supervisors there, that would give better results. I don't know how often you have judges or defense lawyers among your faculty at your institutions, but that's very important from my perspective, because we practitioners, we are not talking about theory, we talk about practical experience and all those practical specificities that are not in the textbooks. So if you have this chance, it would be good if you could get engaged the practitioners, and then they would help the students to develop these practical skills of drafting documents, motions, etc. And then at the end of the day, we'll have the graduates that would be ready to draft documents, will be ready where to find the respective documents, and will be aware of all those specificities that are subject to change too. Thank you. Thank you. Your comment is very important for us. Teaching at the universities, and we fully support that legal education reform is not the issue to be addressed by the universities, but that's for everybody, for the graduates of the universities. Two questions yet, and final comments. That's going to be Anton Demchuk, Dean of the Law Department of Volyn University, named after Lesia Ukrainka, and then we'll have the break. Taking this opportunity of having Mykola here, I would like to raise this issue. Mykola is a member of the parliament, and he is a researcher. Back in 2024, the parliament adopted the law on amendments to the law on the judiciary status of judges. That's on the specificities. of qualification exam. Articles 74 and 82 were amended by this law. That's about anonymous test as to the history of Ukrainian statehood. Now, we have a curricula, we developed the tests, and we started searching for the concept of the history of Ukrainian statehood. In other words, what is Ukrainian statehood and what lawmaker included in this concept. There wasn't any explanation to support this law and these amendments to introduce this type of tests we made before the second reading. We had a team composed of the representatives of the Institute of the History of the State, representatives of the leading universities. So we developed a document and provided this to Qualification Commission, and the head of the committee and members of the parliament suddenly said, well, it's something different that we meant. It's not XIII, it's not Sarmats, it's not the region near the Black Sea. We meant to 2019 or 1919 war for independence. So the question is, what did the members of the parliament mean when they drafted this provision in the following manner, whereby the qualification test included the history of Ukrainian statehood. Is this a subject matter? Is it a science? And what does it cover? Because please glaze that we shouldn't overlook XIII and Sarmats, because that's when the fundamentals of our statehood were shaped. So what is that we should teach our students? What period is covered by this? And again, is it a subject matter or not? Because it is only in Drohobych Pedagogical Institute that has a dedicated subject on that. Nobody else has it. Thank you. Thank you. Very relevant question. And I think that's the way you read it, the sense that we had when we drafted it, and the way it was seen when applying it. But the answer is just there. That's the exam for the judges. Therefore, that's the test is to analyze the competences that the judge needs when administering justice. And when we talk about the importance of XIII and Sarmats, that's a very significant thing. But does a judge need this knowledge when administering judges? I have a question here. What kind of competences does a judge need? That's understanding of the legal acts, what was adopted, how Ukraine integrates European legislation to international legislation, understanding of the conventional provisions when Ukraine became member of different international organizations, when in Ukraine undertook specific obligations and duties as a state. That's what is meant there, because that's what a judge needs when administering justice. We remember very well that the judge should have knowledge not only about a factual legislation. A judge should be aware of the way the law works in time and space. Sometimes the judge receives the case that deals with the collective farms, and the judge should know when the collective farms existed in the history of Ukrainian statehood and how they were governed then. That was the idea of a lawmaker when we mentioned the history of Ukrainian statehood. So a judge should take the test for us to verify whether he is capable to use this knowledge when administering justice. So that's the beginning of 20th century, from the moment Ukrainian People's Republic was established, to understand how modern Ukraine appeared, how it lost the possibilities to become independent, how it became part of the prison of Union republics. After that, it restored its independence, how international developments um, we developing. That's what the judge is to consider when administering justice. Speaking about the history of Ukrainian statehood, I would ask you to accept the fact that it is just an amendment to the law on judiciary and status of judges, and that's the correlation. As to XIII and Sarmats, that's what every Ukrainian should be aware of when studying the history of Ukraine, history of the state of Ukraine, when studying patriotically significant issues, but whether the judge needs this when administering justice, so that's an open question. Thank you. Thank you, Mykola. We have two other comments. Marina Velikanova gave National Shevchenko University head of the Commission on Quality of Education. Dear colleagues, just a brief comment given the issues on the agenda today. I'm really inspired by the presentations and the discussion. I'm really happy that we are discussing these issues in such a broad audience. They're very important and relevant, and it was repeatedly stated today that the quality of legal education is a key element for the development of the state per se. I'll talk not so much as a lecturer, but the head of the Quality Legal Education Commission. Tatiana, Lyudmila, and others spoke about the quality education councils and the criteria that we are guided by to assess the curricula. So the very assessment of the curricula is an evolutionary process similar to legal education development. And Tatiana and I did talk about the changes that we see in the way we assess the curricula. Marta said that accreditation causes fear among many legal educational institutions. So our margins of appreciation and discretion in assessment used to be really wide. We developed our own kind of criteria. At the moment, we have uniform practice to be able to identify any deficiencies if there are any in the curricula. So analysis of the curricula that we receive in our council, and our council assesses the curricula on law and international law. So the issues that we identify are the ones that we have talked about. That second criteria, the compliance with the legal education requirements, that's students' practice, where the students could acquire practical skills at the public prosecutor's office and in court. That's studied by correspondence, and we didn't mention this form of training, but compliance of curricula with the standard is an issue there too. And the key problem that is less often identified in the curricula, but previously it was very widely uh, identified when the number of hours was not in line with this standard. But my personal experience of teaching shows that students that study by correspondence are highly motivated. So we need to make sure that quality of knowledge they acquire in this form is high too. And sixth criterion, that's the one that is subject to regular discussions, that's human resources. And we have our practice that we developed to assess sufficiency of human resources, and we do not narrow it down to licensing requirements. These five publications that are there as one of the requirements in our council, we never assess these publications exclusively as educational element. We pursue a broader approach that could cover several educational elements. And there is another related criterion, that's the system of quality of internal quality assurance control that any educational institution should have. I would like to finish on an optimistic note and say that we have good practice and the ones that should serve as an example for others. For the first time, we have one model curricula with grade A. That's Zaporizhia University that has this program, that's curricula. So there are good results when we talk about the quality of teaching in legal schools. And I think through common efforts will develop approaches that will improve the quality of legal education and quality councils and accreditation process would be seen as a support to increase the quality of education. Thank you, Marina. And final remark from Anton Demchuk. Thanks a lot for the invitation. It's a pleasure to be in Franco Lviv University. I studied here traditions, values. That's something that stays throughout your life. The main comments on my part. Dear colleagues, I think everybody realizes that cross-cutting masters will address most of the issues that we have been facing in legal education today. Why? Because preparation for a master's is very good. I cannot agree with qualification exam for bachelor's, but that's probably good as a filter. But if master's is a cross-cutting thing, we'll get rid of those students that just join in the school from private educational institutions and they are out of place.
So then the number of universities or so-called law schools, they have their law programs. So whether it would address the issue, most likely, this suboptimal quality wouldn't allow them to pass this exam. It would be kind of a natural selection without state regulation. You wouldn't need to close the university. Give them a choice. Yes, this institution has the accreditation and license so far, but ultimately you wouldn't be able to graduate as a law student. And that would be forgotten. And I think it would be one of the best things to reform the legal education. So when they say that there are lots of law departments, a lot of lawyers, a lot of law schools, but yes, but indeed we don't have a lot of lawyers. So there are people with the law degree, but they're not lawyers. So because when students are poorly trained, ultimately they do not become prosecutors, judges, they go into business. They do not practice their profession. And it's not about carving out markets. And so they simply won't be getting the law degree. Another risk that we are facing today, you mentioned legal clinics, but I think they are on the decline because of the free legal aid. Because those clients who went to legal clinics, now they reach out for free legal aid. And if I take one clinic, it has been in operation since 1996. We have good results, good tradition, but 3-5 consultations of clients a month, it's too little. We used to have waiting lists, but now we have just a few clients. Now the students do not have the possibility to go to the court because of the monopoly of the bar. Now it has been replaced by the practice, but there's an issue, and I know that the deans have the problem. We do not have supervisors as a person who would be in charge of this. Large institutions can afford it. As for classical institutions, they cannot afford to have a position responsible for students' practice. As for the admissions campaign, I am finishing. A cut score is a good tool, but let's be frank. I actually went to the law department because I wasn't very good with maths. And this coefficient with the maths is actually a cruel joke. And look at the number of students seeking education abroad. And they are offered free education, free preparatory courses. They don't need standardized tests or other criteria. And there are a lot of questions with few answers. And we kind of our reform is like samurai's path, long and endless, but we are to see the milestones and know the steps and stages, because we kind of see the end of the tunnel, but what is it? Is it the light or is it the train coming? And we are to decide what is ahead of us. I believe that it's the light at the end of the tunnel. And now we take a break and come back in 20 minutes. Dear participants, let's get back to work. So we have a very meaningful and intense day ahead, and it's my pleasure to present a new panel. This is the case law of the European Court and the Convention in the education of Ukrainian lawyers. It's a logical continuation of legal education. And now we will be speaking about the challenges faced by law schools when it comes to teaching how to apply the case law of the European Court on Human Rights. This year, so what we found out that now we can celebrate 20 years essentially. Back in 2006, after the law was adopted. So there were different titles about the case law of the European Court on Human Rights. The discipline was introduced in Lviv, in particular by Professor Rabinovich. So it's a great pleasure again to discuss this topic. So, and now we find ourselves in the situation when participants can already share their experience of teaching and not only teaching. Mr. Gudima, he is the professor at the law school, and as judge, he can present the challenges faced also by judges when lawyers apply the case law of the European Court. So there are a lot of concerns with the application of this case law, whether it is not relevant, not systemic, or sometimes incorrect, lifting out of context some thoughts, some ideas. So I think we have a lot to talk about. So it's my pleasure to present the panel and the participants. So Mr. Gudima, Judge of the Supreme Court and also professor at Lviv University. Tamara Dudas, Doctor of Law, Associate Professor of the Department of Theory and Philosophy of Law at Lviv University. Anton Demchuk, the Dean of Law at Volyn National University. So we have also another representative from Lviv University, and online it's my pleasure to present Ksenia Smirnova, professor of comparative law at Taras Shevchenko National University of Kiev. I hope you can hear and see us. We invite you also to participate in our discussion. So the first thing I would like to offer for the discussion so what are your challenges when you introduce or implement in your courses the case law of the European Court? I remember my education, so it was offered within different courses. So again, what are the challenges when you try to introduce this discipline? And in the process, what are the most problematic things? I suspect that most of you would also quote that there are very few hours, but who would like to start? Thank you. Maybe I'm among those who were one of the first to introduce it. So I had experience to translate the judgments of the European Court. And I would like to remember the fourth forum here in this university, and one of OSCE experts after my presentation mentioned that this case law is not for students in general. It's too early. They don't understand a lot. This is already for more educated community. So I'm very happy to see that the focus has shifted on giving the quality for students, because I believe that starting with students, we can gradually introduce this discipline, the argumentation, and all other aspects to help train our lawyers. And if we look back at this course, first it was a terra incognita. There were no sources, let's say, very few. There were just a couple of textbooks, and I remember that on the lecture on the freedom of expression, I had journalists, students, because they were interested, and it was the only source of information. Today, one of the challenges is abundance of sources, where you need to sort out and to pick what really merits attention, and the skill to work with abundant sources is something to be also developed in our students. Another challenge that I would like to highlight today, there is a link between how we teach the students and how it is later reflected in the application of law. So it's excessive citation of case law and lack of analysis through the lens of the convention and judgments. It's a substantial problem. It is being gradually addressed, but the approach to training students has influence, because we now teach students not to cite but to apply. It's not just the knowledge of judgments and decisions. It's not about it. You are to be able to review and check the modes and the algorithms. And another challenge that I observe is to make an absolute of this three-step test. From what we hear and see in reports and decisions, it may seem that the entire case law is a three-step test. It's only for articles for the freedom of movement and for some protocols. For articles 5, 6, we do not apply it. Therefore, we need to shift the focus. So it's not only about this three-step test. And we need to start with students. And this is what I am attempting to do, showing the variations offered by the European Court on Human Rights. Another challenge, and something that needs to be addressed, is that instead of giving information, we need to focus on building the skills to analyze, to review, to look for sources. For example, find a case about the boy who died because of electrocution in some station, I think that this should be something that the students are able to do. And then there wouldn't be the question how to find decisions or judgments by keywords. So it would be elementary. But we do encounter this situation. So the database HUDOC is a very important thing, and it should be a basic skill. Then, as for the methods, the key method should be simulation of trials, of court trials, or court proceedings, because the judgments, the knowledge of judgments is important and useful, but to read it as a detective story, yes, sometimes they're really exciting, but you are to, we understand without reading, we cannot do without it, but it's about how. About the principles and how to apply the judgment and decision. And finally, I want to draw your attention to the challenges of the war. And here, in the disciplines relating to the case law, we need to speak about derogation, because it's not, so easy in this Article 15. There are definite rights with limitations, without limitations, and the students should know and understand the difference, and they are to be trained to apply the criteria of derogation in Article 15, and to explain that if we have a three-step test, Article 15, it's already about proportionality. To sum up the challenges, maybe it's an ordinary thing to say, but teaching disciplines relating to the ECHR case law should be about teaching to feel and understand the spirit of the convention through understanding of its letter. Thank you. Thank you also for highlighting the present day challenges, because we used to speak more about promoting, providing wider information about the convention and the case law. Today, the focus is on application and the three-step test. It's not everything. Now, I would like to ask you to join our discussion. You have experience of teaching international law. So, what is the role of the case law of the European Court on Human Rights? And so, what are the challenges when you teach students of international law? Thank you, dear participants. Esteemed gathering, it's my pleasure to be part of this panel and the topics raised yesterday and today. Organizers, thank you for this kind of a unique agenda. If it were a thesis, I would say that the structure is really very exciting and very robust. We heard one of the challenges is application of the case law in civil proceedings. I want to look at it through the lens of Ukraine's accession to the European Union. We have heard from our colleagues today that when Ukraine is meeting the criteria of accession, the first cluster, fundamentals, is of paramount importance, and it includes also the values of the European Union. And Professor Smirnova will add to this. She is one of the champions of international law and the EU a key in this context. I understand the time constraints and all the events. Yes, the case law has been a challenge. It was difficult, I admit. And now we are offering comprehensive programs because we merge the case law of the European Court on Human Rights and the Court of the European Union, and understanding, first of all, that these two courts, the Strasbourg Court and the court in Luxembourg, they are not competitors in their jurisdiction. There were just a couple of cases, but it's not a competition in terms of jurisdiction, but they shape a single legal space in the EU, and the EU standards that we are to abide as the candidate country. It's about the status of judges, it's about media, it's about combating corruption. And when we conduct methodological workshops and when we combine these two disciplines, we want to have similar focus on both case laws through the lens of Ukraine's EU accession. This is not an easy task. We face different organizational challenges. We have heard about the search of cases. I will try to be fast. So there was a case with the interface of the court in Luxembourg. They changed the interface several months ago that practically complicated the search for those who were not professionals. There were lots of complaints. So without special paid search engines, it was impossible to do it. And it was interesting that they got back to the old approach and they are working on new methodologies, but this is a good actually example in this context. Thank you. Here I suggest that Ksenia Smirnova joins our discussion. Yes, I also like the approach. And in some sense, it's a kind of an innovation to teach the case law of the European Court on Human Rights together with the case law and the Court of Justice. It's interesting, but it also presents a challenge because it requires additional expertise. Ksenia, please, the floor is yours. Thank you. It's brilliant moderation. Dear participants, dear guests, I'm extremely happy to be able to thank the organizers for this forum. Unfortunately, I cannot be with you in person, but in spirit, I am here. And today's conversation is a logical continuation of what Mr. Golovati said today, and the first panel on the reform of legal education, because when we heard Mr. Burdin, I do agree when we speak about the reform process, not kind of an institutional or surgical methods, when we focus on the content and the quality of legal education. So application of the case law of the European Court on Human Rights and the Court of the EU. So it's developing the spirit of law in the context of natural rights. It's key, and how to teach this. I would like to share my experience, and for example, what do we have in Kiev University? And then I would answer the question about difficulties. When we speak about application, so it has been a long journey, and it's not only law schools since 1995, it was also for courts, for judges. Today, this topic is cross-cutting, and it is integral part of three levels of education. At the undergraduate level, it's about fundamental knowledge. At master's level, it's understanding and application. And the third level, doctoral level, it's about the most sophisticated and complicated application in particular situations. So
teaching students how to use database systems and search engines. That's very important element. But there is another important tool that I would like to mention that is used in our practice. That's Institute of International Relations. That's what we started practicing in 2017. So that's Help platform. The courses of the Help platform became part of our curricula. Just a brief example. I had a course comparative criminal process. I am teaching this at the Department of International Law, and the course started with the adoption of the new CPC. Can you just imagine? The comments were missing. There is a comparative aspect whereby we should study different legal systems and European court case law. So I accessed Help platform, and having identified the relevant courses, I started recommending them to the students for their self-study. So that became one of the elements along with the simulation games and other tasks. So they started seeing that from the perspective of the courses that were developed for help. And help was not meant for the universities, that's more for civil servants and legal professionals, but with the beginning of COVID-19 pandemic and the challenges related to it, when we had to study online, Help platform became an important tool that served as an additional source of information for the students. And we see how actively Help is used by all law schools. We see more and more courses translated into Ukrainian. Some courses are developed in Ukraine. And that's one of the success stories that we could refer to and use it as additional tool. So case law should be part of different subjects, and we shouldn't focus on just one subject. Well, it is possible, but that would narrow the application of the case law. To answer your question as to the challenges, we've heard them mentioned today. Where to find professionals, lecturers slash practitioners that will be able to provide this knowledge to the students from practical perspective. There is a high need in ongoing systemic professional and advanced training that would be focused on in-depth understanding for all the issues and sharing this with the students. And it's not only about the European Court case law that includes the international courts. Court of Justice case law is also of crucial importance. Recently, we had the president of the European Court of Human Rights visiting Ukraine. When he came to our university, I dared to ask him the question how European Court of Human Rights case law can be combined with the European Court of Justice. And here we are talking about shared values, ongoing communication, constant meetings of the court in Luxembourg and the court in Strasbourg. And that serves as the platform to develop uniform approaches in application. It develops uniform approaches and criteria and uniform approaches to the reasoning. And law is a living tool, and therefore we shouldn't pursue the positivist approach whether this or the other provision should be included. And despite the fact that the discussion can continue in the future as well, whether jurisdictions between European Court of Human Rights and Court of Justice should be divided. Anyways, I heard that there is a synergy between these two courts, and we don't see the institutionalization in terms of merger, but it's more about the synergy of approaches and actions. Therefore, the issue of teaching this is becoming even more important. I'm not going to talk about the number of hours, how can we fit all of this in the allocated number of hours, because the lawyer should know all the basics. The rule of law, in particular, especially given the processes, legal processes that we are part of related to EU accession. Fundamentals is about the values and the way they are applied. In the course of teaching, we can face some complexity in applying the case law, not only in terms of law enforcement, but in terms of enforcement of the judgments. And we need to talk about that. And we, therefore, need to develop respective mechanisms to enforce the judgments of the European Court to be able to apply the jurisprudence better. We have success stories. We have cross-cutting institutionalization. We see practical element. We see how these issues are becoming an element of our teaching, but a shortage of professionals that would be both scientifically and practically able to share this knowledge and practice are the issues that require attention. Thank you. Thanks a lot to you for your perspective. Honestly speaking, after these arguments, after the arguments of McCall and yours, we started being a little bit more concerned because, we seem to be okay with the European Court case law, but now we have to move further and be able to apply the case law of the Court of Justice. We need to learn this to be able to teach it. So that's another thing to be kind of, nervy a little bit to some extent. Anton seems to be calm, so maybe he has his own recipe of dealing with that, and therefore your school knows how to address the challenges. Thank you, Ksenia. Thank you for your comment. It seems to me that 70% of my comments were covered by you. Just a few words about the practical experience of our law department. The dean has a difficult task. European Court of human rights case law should be part of bachelor's and master's, and that's a very difficult task for the dean because we need to train students properly, and the student should be competitive, and the student should be competitive when he is able to deal with European integration processes. So what can be done here? And that's what we are trying to do. That's a mammoth task, but it is harder to grasp when you talk about the entire European Court of Human Rights case law. But we have possibility of having selectives for the students and therefore grasp more of the issues more in comparison with fundamentals. Another step that we have is information technologies in law. That's a subject that teaches how to work with registers and databases because the student seems to be okay initially, but when they access the website, they seem to be lost because there are lots of filters, there are lots of criteria. So you have to be professional to be able to find the document at a specific database. The next thing is modules in standard subjects. I teach civil process, and one of the modules there is European Court case law. We show how it can be integrated in the national legislation. So these things are cross-cutting, and it's not a dedicated subject on the European Court case law, but they are cross-cutting and help. We joined in, and that's a very good tool for informal education that can be combined with formal one. Some modules, parts of modules that could be taken into consideration as part of the credits work well. It's not for all the subjects, but most of the modules that are there could be recommended, and I would insist on the teachers to take them into account when assessing the students. So if the student got the help certificate, that means the student got specific knowledge. And this certificate should be considered because that was work and the student invested time and efforts into that. I take some help courses as well, not all of them, but only those that are of interest to me personally, but they are very valuable. Thanks a lot for all these comments and proposals. There is always room for improvement, but we need to keep developing and applying best practice and joining efforts, having discussions like that prove that we are not competitors. We all contribute to improving and making education better and increasing the quality of education services. Thank you. Thank you, Anton, for sharing your experience as a dean of the law department. And thanks a lot for sharing your experience of approving curricula. Tamara said that there is a lot of different information and different tools of acquiring this information. Ksenia and Anton mentioned some of the tools, and you have to have some skills to be able to use these tools. And it's not always the case that the students are able to use available tools. So that's require some teaching as well. We have another speaker. that is going to speak the last. I wanted him to be the last to speak. Dmitro is going to share a unique experience in a way because he can see it from the perspective of a lecturer. He's been teaching for a while. I was his student. He is a defense lawyer that submitted applications to the European Court of Human Rights. At the moment, he is a Supreme Court judge. So his comments are really important for us. So the floor is yours, and could you please focus on practical aspects, but also on some kind of recipes for the faculty, for the guarantors of curricula as to how we can study European Court of Human Rights case law and how we can study jurisprudence of the Court of Justice. Thank you. Thank you for the floor. Let me thank Lviv University for the invitation. Let me thank Council of Europe and OSCE for the support to the project. Thanks a lot for being with us for many years. If I'm going to give any recipes, I'm not sure, but as the person that started teaching in the year 2000, I do have some ideas as to deficiencies in education, given my personal experience, and I would like to present them as a judge, since I know how specificities of teaching European court case law could be revealed in practice. I don't know if that's a specificity of the law department where I used to study and I'm teaching now. Some of the deficiencies have been eliminated. There are some novelties that have been introduced, but let me share some ideas as to how we can organize this teaching. It seems to me that the issue is mastering convention as a doctrine, interpretation of dedicated provisions, and use in European court case law as some illustration to this subject matter. Second, we tended to use abridged judgments of the European Court, just a little bit about the facts and the conclusions. And the third is analysis of the European Court judgments as linked to the facts of a specific case. So, therefore, it is the knowledge that is subject to testing rather than the use of the arguments. Broadly speaking, we can say that in Ukraine we see that the preference is given as to what was decided. Well, in fact, we have to teach as to how the court came to this conclusion. And that's knowledge centered teaching rather than decision making skill. Because the decisions are made by defense lawyers, by prosecutors, not only by the court. So we are talking about seeing the issue as a solution. So therefore, we need to switch from learning and analyzing the result and focusing rather on the process that leads to this result. And here is several ideas that would be in the form of recommendations. Give up on lectures. The student should have a set of methodological recommendations, textbooks, lectures, analytical analysis, and set of judgments necessary for the preparation for the class. We need to develop the tasks not on the basis of the cases decided in the European Court, but on the basis of the national cases. Arguments regarding convention violations are often that we can see. They could be of different level of quality, but nevertheless, violation of the convention often referred to by the parties to the case. And that's a cross-cutting practice that we see today. So these tasks that would be developed on the national case law would teach a student as to how to work with the convention linked to the national context. European court case law should be used when analyzing the facts of the case that served as the basis for the respective judgment. So the link between judgment and facts, and the teacher should change some elements of the task, some criteria to see the opinion of the students, where the judgment of the court would have been different if the facts were different. That would allow the student why the court arrived to a particular judgment, and whether this judgment or conclusions would be there if certain circumstances were missing. Convention should be taught through showing the link of the convention provisions to real life situations. So the model is from fact to principle. Through the knowledge of facts and the assessment, we are arriving to the principles of convention that reflect it. Practical tasks should be focused on developing the skill of the students using the proportionality, necessity, and legality. A lot of cases before the Supreme Court is completed, landed before the Supreme Court just because the courts of the lower instance did not assess proportionality of the arguments. So there is lack of understanding how this three-pronged test could be applied and what is subject to assessment when we talk about balancing the interests. Part of the tasks for the students should be dedicated to the mapping of the judiciary. So depending on the content and European approaches, the students should be able to see the areas where European court leaves maximum to the margins of appreciation by the government, while in other areas it is limited.
I think that we are to allocate a couple of classes for this role playing, where they could take on different roles, and the teacher would be the arbiter, putting the right questions to understand the deficiencies of arguments, for example. And of course, it is important to integrate the study of case law with such disciplines as the constitutional law and others. So ultimately, the students should understand what was important and relevant for the court to take these judgments or decisions, what was the balance between private and public interests, and the scope of discretion for the state, or the margin of appreciation in particular cases. Thinking about the master's program, it could be more sophisticated things, like the skill to forecast or predict the decisions, students understanding the convention, the argumentation, the operation of the court, having this basics, they already can try to predict the judgments when we look at the typical problems. Secondly, we could try to look for trends in the development of the case law, taking the examples from the past and present judgments, because the convention is a living organism and the case law has developed significantly through its history. And the master's students could also be taught to understand how different societies operate through the lens of the complaints. And this is a reflection of what is happening. And looking into the statistics regularly published by the European Court is also very interesting material, especially when we link it to countries, populations. I think starting from 2010, the European Court has been publishing statistics on the number of applications against the state in relation to the population, even though it is not immediately obvious. It is a good indicator. And if Ukraine has always been on top when we take the number of applications, if we take proportional to the population, if we take, for example, the period before the war, so through the judgments of the European Court and looking at the opinions of judges, we can look into the mindset and look also the countries from which they come from. I think that for master's students, for their horizons and understanding how the court and judges operate, I think it is really important. This is all that I wanted to say. If we try to teach this, I think that we can achieve the progress when it comes to the quality of texts written by different parties of the proceedings. At least 3 schools have received recommendations. I think you can even ask the organizers for the recording in order to go back to it. And I think that the role of moderator is also to have timely ending. We have 5 more minutes allocated for final comments or final questions. So it's my pleasure to invite everybody to contribute. Please, the floor is yours. Gonchar Lubov, head of the division of training of trainers at the National School of Judges. I don't have a question, but I would like to thank you for very interesting interventions and would like to share the experience of the National School of Judges, how we deliver the training to adults, the judges. We have 3 types of training. So this is the initial training, which is mandatory according to the law. So then in-service training. And we also offer initial training of newly elected and appointed judges. It's mandatory for them if they have never been a judge. So people who have come from academia, from the bar profession, and it's mandatory 300 hours. The National School of Judges designed courses on the case law of the European Court of Human Rights for every jurisdiction, and I'm very proud and very happy that we already apply the methods that you have recommended for students. So we offer judgments of the European Court on Human Rights to be further discussed during the training. And we ask them to solve practical cases. So, and they consider the possibility to apply different judgments. In our workshops, we always introduce modules on case law of the European Court on Human Rights relevant to the topic of the training. And we thank the partners, the OSCE project, Bravo Justice, the Council of Europe project. So we engage esteemed international experts to teach these modules. And we can also boast that we use the platform Help and the training activities relating to the application of the case law of the European Court of Human Rights. And we have also designed distance learning courses that judges can take at their convenience. And for the initial training, we have the coordinators for the civil, economic, administrative justice, criminal justice. So we have courses on writing court decisions and judgments, and we have a wonderful lecture on how to cite and use the argumentation contained in cases of the European Court on Human Rights. Yes, thank you. It's very interesting when we speak about adult education, but I think that maybe you will need in the future to think about something else. And thank you for this intervention. So it's not if, it's when. Maybe we have already done a lot of things. Thank you all for all your thoughts. I think it reflects a lot of my thinking, but my impression is that you've been talking mostly about knowledge, how to find a decision, etc. But for employers, and I used to be an employer who recruited people, they need a solution, not a judgment. So it's wonderful, all the credentials and everything, but they asked, okay, show me. So this is the fabula and how you arrive at the decision. So between knowledge and application, there is a certain myth. I think Metro has already mentioned it. Maybe I'm mistaken, but it's about mentality or mindset. An example, there was a woman and it changes gender and becomes de jure man. Then she gives birth to a child. And she insists that in the birth certificate, this person is recorded as father. The state rejects, and this is a new case. And here the lawyer, they need to have some legal background, the tools, the mentality. They need to draw a path towards the solution. So the biological woman, the jure man, and being recorded as a father. And for that, what to balance? What's on one side? What's on the other? and how a person would go on living with these documents in a democratic society. And this is something that should also be taught. Otherwise, it would be just pure knowledge. And they wouldn't be able to walk this path. Thank you for this reflection. I understand and what you're talking about. It's about mindset, about mentality, and it's a huge task actually to combine all this and the principles, not only the ones that are enshrined in the convention, but more general principles. And I believe that the law schools are doing a lot, at least to attempt to integrate it in the academic process, with mixed results. But as Deputy Dean, I can assure you that we do have it. A short comment. I see. Yes. Thank you for all the recommendations. Everything is very useful. Everything is implementable with the word but. But the number of hours allocated. We have credits. We are to meet the standards. If we take 5 credits, it's maximum that can we afford for a subject. Let's say 15 lectures and 15 seminars. This is maximum that we can allocate for fundamental disciplines. 3 credits for the case law and the convention. Materials and practical cases, I love it for masters. I'm not sure whether undergraduate students are ready to do a lot of independent learning. We are to review all our curricula. I think that, so if we do this reform with the master's degree for law students, I think that we can continue our conversation during the lunch break. Thank you for responding to what I have been talking. I actually was speaking about undergraduate courses and also speaking about this 32 hours, traditionally 16 lectures, 16 workshops. And my proposal was actually to do away with the lectures. I think for the 3rd or 4th year students, it's quite possible to work together with teachers who are knowledgeable and to do it through seminars. Of course, we need materials, we need textbooks, we need very good moderation and facilitation on behalf of the teacher. But even having limited hours, a lot of things can be implemented. Thank you. Half a minute for final remarks, but I will be really strict. Igor Balitsa, Volyn National University. To continue the thought about pure knowledge. As a lawyer, when I used the case law of the European Court in Human Rights, and when the courts rejected, I felt really disappointed. And we need actually to tell students, I had to tell students that it's not always that the same judgment could be used, and it can work in positive and in negative way, so that students or the lawyers should understand that they need to develop and improve themselves. Dear participants, see how many problems we see in legal education and in studying the case law. I thank all the panelists sincerely. I thank you all for participating in this discussion, and I believe that with joint efforts we will be able to present the case law. And we come back at 3 p.m. to continue with the conference. Thank you.